Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, and holding up half the sky. Raise your hand if you're ready and willing, if you know it's time. Time for a girl on time. Time for a girl on time. Time for
Well, dang it, she said, as she thought she was organized and then she was not. I hope everybody's doing well for this late night, Friday night stream. I got to admit something, you guys, and I wish I didn't have to say this, but I am cursed. Today especially, for some reason, I have broken so many things. I can't even recount them all. NPC, you're so sweet. Yay! Wow! That's so sweet. My mood is immediately improved, and I'm feeling a little bit confident that we might even have a show tonight. Thank you, NPC. Welcome new members. Look forward to a Sunday members only. I'm excited for it. But what I was saying is that I've literally broken so many things today, and I thought that I had left it behind me as I came home today. And then the files that we were going to watch were broken on my other computer. Something I haven't experienced before. So I have part of it here. We can watch the part that I have, and that's what we've got tonight. So we'll just make do with what we have. Hi, Eve. Look at the names. I love to see our friends in the chat. I would love to hear what you have for dinner tonight on this Friday post-Thanksgiving Eve. I would love to know who amongst us had turkey or something entirely different for dinner tonight. Let me know in the chat over there. And in the meantime, please accept with my humblest of apologies this clip, this part of this hearing, which originally, I had the first part on my other we're not making a big deal about it. Regardless of it, what we're watching is what I've got. I'm mad about it, but it's what we've got. Where is this 10 minutes from? Is it 10 minutes from before or after? I think it's from before. Okay, so I have one 10-minute clip and 1 hour clip. So we're going to do both of them. I'll do the 10-minute clip first. Please understand that an hour preceded this, but I'll summarize for you because I listened to it. So once we hear where we're at, I'll let you know what we've missed. Dad is pro se. Mom has a lawyer. They are fighting about... oh man, I hope we got the good stuff that the judge said. He said such cringy stuff. Like so much cringy stuff. So cringy. Oh my god, my real room is showing. Jesus Christ, that's much worse than the green screen. Remember, does anybody remember, of course some of you do, when we used to do shows just straight from my kitchen? Oh, the good old days. Anyways, 10-minute one first. Okay, so what happened?
We're here in the matter.
Judge. What? Maybe this was at the very beginning. Whatever, we'll watch what we got. I'm pretty sure. Hold on, let me just listen.
Attorney fees on the line here, sir. So get to a place where you're safe.
Hold on, never mind. This is after. Oh, Jesus Christ, my desktop is almost as bad as my room. Jesus Lord.
She just heard that and she said never again. Basically, it was a dad's weekend for college for my daughter, and I screwed up and I had a hearing that afternoon. And she's like, well, we promised our daughter we'd be there for dinner. And I'm like, I got a hearing from 2 to 5. And my wife's like, she goes to Indiana University. That's 5 hours from our house.
Yeah.
We're not feeding her dinner at 11 p.m. So in consequence, I wound up doing a hearing from the backseat of a car, which everybody didn't really notice because I have the same fake background on my phone, except every once in a while I did this. And then I also had a sash from here to here, which was the seat belt. But that's what Zoom is. And Mr. Granley, I'm sorry, but we cannot have the witness in the car. Okay. It does allow her to ask for attorney fees for any delays. So.
Okay, so I'll summarize what happened. When on the other computer, well, I mean, I'll try and get the rest of it, but it's not happening right now. Anyways, we started this hearing out. Buddy's girlfriend was in the car, and he said, no, she's going to testify. And so the judge said, well, she has to get out of the car. And so she was out of the car, and they did about an hour of testimony. Hi, Erica. And finally he interrupted and said, hey, can we take a break so my girlfriend can drive to where she needs to go? And the judge said, yeah, no problem. And that is where we're picking up from now. Also, the judge, I think, is going to notice, I don't know if he's going to notice soon or not, but there's a third person in the room with the wife, and that's her emotional support human. Anyways, hi, Sherry. Thanks, Erica. Honestly, I've broken so many things today. I'm not even joking. Files, physical things, fucking brain cells, all of that I'm afraid to do almost anything at this point. But we're going to continue.
We're back on the record in the matter of Granley versus Granley, or case number 23-112360M. We're still on the record. Ms. Granley, you are still under oath. Please proceed, Ms. Wattsday.
Thank you. Ellie, you were providing testimony with regard to an incident that occurred on October 28th of 2023. I think you, if I could summarize, just testified that the defendant had left the state of Michigan without your knowledge, contrary to an agreement that the two of you had reached just days prior. Did he acknowledge initially that he had left the state?
So that morning of October 28th, he had told me that they were going to be here in town doing trick-or-treating. I found out through our joint bank account that he was in Chicago.
Hold on, ma'am. Hold on. Hi, MB, by the way. So nice to see you. Are we being realistic right now that, first of all, I have to admit, I made up the term emotional support human. I made that up. But my point being, they never described her as that, although I would, having watched this. Secondly, would that not alert something to you if my husband, ex-husband, partner, person in charge of my kid was like, oh, we're trick-or-treating. Oh, on October 28th? Fucking where? Absolutely, where are you fucking trick-or-treating on October 28th? Nobody. At least not in Canada. It is just not a thing. So, first red flag. Ma'am, did you just set that aside? Okay? First problem.
And confronted him over text asking where they were. And he continued to tell me that it was none of my business and that it did not matter where they were at the time.
I'm going to ask you to look at what is marked as Exhibit 9. Is that text message that was between you and the defendant
Yes, it is.
on the day in question?
Yes, that from that weekend.
Okay, and that's what you were referring to. He simply refused to respond and would not provide information.
That is correct.
Okay, we move for the admission of Exhibit 9 as court's Exhibit 10.
Mr. Granley.
No objection.
All right. In that case, that will be entered into evidence at this time.
Did you speak with with the defendant on that day?
I texted him briefly. He then informed me that his phone was dying and I did not hear anything else from him until he dropped CJ off late that night.
Okay, and how did he appear when he dropped him off? What was his demeanor?
Very anxious. He was speaking very rapidly. Some of his speech was slurred. I tried to get information on whether or not CJ had taken a nap that day or when he was last fed, and it was just very unintelligible what he was trying to say.
I'm gonna ask you to look at Exhibit 10. Is that a text exchange?
Eventually, I might get Mike to try and help me figure out the files on the other computer because it did fucking record, and there was a lot of stuff before this that was alleged. The lawyer is already pissed off because the judge is leaning over backwards to sort of help this guy. She made a motion to sort of admit all of these documents, and the judge denied her motion basically and said, absolutely not. I've been fucking bit in the ass for that before. You'll enter everything one by one. And he's not contesting any of it or objecting to it, but the judge told some really weird story about admitting 500 pages of a psychologist report and nobody elicited any testimony on it, and he said that he had to read the whole document, and ever since then he's learned his lesson. And I think that's probably correct. He said specifically, he's like, when there's a pro se litigant, we have to lean on the side of going through everything one by one because it's an easy appellate issue if they look through the record and look and see. I mean, he didn't say it, but in as many words, the lawyer's lawyering above this defendant on purpose is what he's trying to avoid. And so, yeah, I mean, she just got real pissed off. Her face, like, I can see it, but I have really good eyesight, as I recall. The one thing I still have today, I'm not joking, I'm afraid to even touch the mouse now with how much shit I've broken today. I'm not kidding.
Between you and the defendant's mother?
Yes, it is.
Can you please summarize that for the court?
This is a conversation I had with his mom, saying what was going on, that Chris would not tell me where they were on that day, and her acknowledging that.
I move for the admission of Exhibit 10 as the court Exhibit 11.
Mr. Granley.
No objection.
All right, that'll be entered into evidence at this time as exhibit number 11.
I'm also going to ask you to look at Exhibit 11. Is that a picture that you took?
Yes.
And when did you take that picture?
I took that picture the following morning, so October 29, 2020.
And what does that picture depict?
That is the sippy cup that Chris dropped off with CJ. That was the sippy cup that CJ had with him in the car on that Saturday.
And are you concerned about the state of that sippy cup? And if so, why?
Yes, there was mold growing on the sides of that sippy cup.
On the inside of the sippy cup?
On the inside.
Okay. And it's your understanding that was a sippy cup that your son had been using the day before?
That's correct.
hold on, hold on. Once again, that kind of shit, first of all, there's two things I want to say. When my daughter was young, sippy cups have like 3 parts to them. They have the cup, they have the top, and then they have a device that stops it from leaking. And it's a plastic device that goes into the holes and basically means they have to suck on it in order to get it out. That's what she did. Anyways, but the whole point being that as a new mom, you learn. And I learned because I used to drink my daughter's drinks when I would make them. And I would like fill it and then drink it. And one time I was like, ugh, ugh. And basically I had gotten sippy cup moldy fucking dish water that had, I remember it. Anyways, after that, I took apart every single sippy cup in the house. And I thought, had not thought about this. And I was young. And that's just the way it is. You don't think about these things until it happens. But it doesn't happen overnight, okay? And it doesn't, if you're cleaning them properly, like if he has the cut, what I'm wondering is how long did he have the kid? If he only had the kid one day, the moldy shit is probably her fault because she had to send it in a state. You know what I'm saying? Like, it's not going to mold overnight. It's not going to mold in one day. It's probably going to mold in like 2 to 3 to 4 days, depending on the environment. So, did he have the kid for 4 days? Did you see the kid drinking out of this sippy cup? I have questions.
I move for the admission of Exhibit 11 as Court Exhibit 12.
Okay, Mr. Granley, any comments?
Just the objection, that's not I didn't purchase that sippy cup. That's not one that I used. So I'm not sure whose that is, but
Okay,
that's
so
not my personal sippy cup.
this was not one that was used while the child was with you?
No.
Okay,
I use all the same brand. I still currently have all the same brand sippy cup. That could have been one that was in the car or just one that got replaced, but that's not. We had went to Chick-fil-A that day for lunch. He had not needed a sippy cup. He had a bluey tin can. So no
Okay.
objection that that's a picture of a cup. A picture of a cup. That
I what I'm going to do is enter it as a picture of a cup, but Miss Granley, you're going to have to show that that was the one that was used. So we'll enter it as pretty much an exhibit, but he does, and Mr. Granley, you're going to have to cross-examine on that. So please take a note that you got to bring that up because, but the cup was with him, to your knowledge, Miss Granley.
Yes, Chris had CJ's diaper bag with him, and that cup was in the side pocket of the diaper bag.
Okay, but you have no knowledge as to whether that was the sippy cup used during that weekend.
I just know that that's the sippy cup that he came back to me with.
Okay, but it was also the one that you sent him with.
No, that came from Mr. Granley's home.
Oh, okay. Why is there no lid on it?
That was when I took the lid off to dump out whatever was in it so I could put it in the dishwasher, and then I noticed that there was mold on the inside.
Okay, sorry, I'm just trying to make a record as to trying to figure out what that is, what it means, and does it mean anything or does it mean a lot? Okay, so I'll enter that as an exhibit, but at this point in time, it is, as all the exhibits, they're under cross-examination. Please do not forget that, Mr. Granley, because you have to take notes, and this is what, if you forget it, when I rewatch this hearing to make a decision, sometimes testimony is elicited and then not contradicted. So it becomes testimony of the court. Okay.
Yes, sir.
And I understand your concerns, Ms. Granley, but let's find out if it was actually used or not too.
So MB, a lawyer would immediately make a note of this upon cross-examination or a redirect or whatever it is, and they would talk about the fucking sippy cup. And he's gonna forget. We know he is. He's nodding yes. His hands are not moving. They ain't no note being taken right now. And this is the tragedy of representing yourself in a case such as this, right? Like, look at him. He's fucking focused. He's focused. He's taking mental notes. But there is no note being taken in the car that he's appearing to court in. Hi, Cellulite Yoga Pants. I have a curse today, so when I touch things, they break, and we're trying really hard not to break anything else. Except for hearts. Anyways. Seriously, I feel him. Like, I look at him, and I'm, like, looking in his eyes, but look at Judge's eyes. Judge is like, bro, I have been giving... I'm like, he's hand feeding the judge, or the judge is hand feeding him these. He's like, you need to make a note of this. Notate this. The judge does look crazy at this moment. Oh, we all need some gummies. Ugh. Beverly's back. Hi, Beverly.
I get it. You get that back and you're like, what the? But in any event, let's proceed. That'll be entered as a court exhibit number 12.
There might be a live chase. Let's see who pops off on that.
It was the proposed exhibit number 11. Please proceed, Miss Watts-Day.
Thank you. So just to clarify, Ms. Granley, the sippy cup that was in that exhibit does not belong to you, correct? Was it sent by you with CJ for that parenting time?
No.
Had you ever seen that sippy cup before?
I knew that it was one of our previous sippy cups that Chris had kept in his possession.
Okay. And that sippy cup was in the diaper bag when it was returned to you?
Yes,
Did you remove it from the car and put it in the diaper bag?
I did not.
Okay, so it must have been Mr. Granley that put it in the diaper bag?
That is correct.
Okay. Moving on, did Mr. Granley indicate why he had gone to Chicago?
He told his friend Vince that his only point to go to Chicago was he just wanted to go have fun.
Okay. Was anybody else in Chicago?
I did not know at the time if anyone else was there. Chris confessed to me at a later date that he did go there to meet his girlfriend.
And this was contrary to the agreement that you guys had just made that you would not expose the children to any significant others
That is
for
correct.
a period of 6 months?
That is correct.
When you observed Mr. Granley that day when he finally returned CJ, did you believe that could you, based on past experience, make a personal observation on whether or not he was taking meds or whether he was consistent with his treatment?
Based on what I observed from him and the actions that were made that day, to me, it was very clear that it was a manic episode, which he does not have when he is stable on his medication.
After that incident, did Mr. Granley return to Pine Rest?
Yes, he did.
And what is your understanding of what occurred while he was at Pine Rest?
Pine Rest told Chris that he was spiraling in a manic episode, and they recommended more treatment.
Okay, I'm going to show you what's been marked as Exhibit 12. And is this text message from the defendant?
This is from Chris, yes.
Okay, and what does it state?
This is a conversation between him and his friend Vince. This is Chris saying that he knows that there's an issue that.
I'm sorry, we need to talk about it. I broke my own stream! Do you see that? I caused the chase, whatever is happening, whatever chase is gonna throw me off of my fucking game tonight. Thank you, Paisley. You broke something else. Everything tonight.
He's not well. Chris says directly that he's spiraling and that he can't recognize when it's happening.
I'm going to move for the admission of Exhibit 12 as Court Exhibit 13.
Mr. Granley.
No objection.
All right, exhibit number 12 will be admitted as court exhibit number 13.
I'm going to also refer to you on Exhibit 12 to the third page. Is that a text message between you and Mr. Granley?
Yes, it is.
And in that, is he acknowledging that there was an issue, and is he bringing you up to speed on the change in medication, et cetera?
Yes, this is him letting me know he had another appointment with Pine Rest, that they are adjusting his medication, that they believe there's still an imbalance going on, and that he recognizes that that needs to be fixed.
At this point in time, was the defendant still living in Michigan?
Yes, he was.
Okay. I want to refer back to Exhibit 12 just for a second. On that second page, does he indicate, is the defendant indicating that he's resigning from his current employment?
Yes, on November 9th, he texted, this is a text to his friend Vince, that he is going to resign from his position.
Okay, so he was voluntarily leaving, stating that he knows it's the right thing to do?
That is correct.
After he resigned from his position in at Cornerstone, what did he do next?
I was made aware that he was planning on moving to Indiana to move in with his girlfriend.
Okay. Do you understand, or what was your understanding as to why he was making that move?
I was not clear from him what the reason for the move was. I had reports from other people. He said that he wanted to move for his mental health. He said he needed to move because he couldn't find a job here. One report was that he felt unsafe because his motorcycle was stolen.
Okay.
All right, hold on. I heard a sneeze. Who sneezed? Was it a dog? Okay, never mind. That could happen.
It's not
Never,
bad, yeah.
I just wanted to make sure because I didn't see anybody on Miss Watts' Days thing kind of go at you. So okay,
Yeah,
never
that's
mind.
not-
All right, that one's
that's not
okay.
bloody.
No problem. Bless you, dog. In any event, I just wanted to make sure there was nobody else present. Forgive me. This is being recorded, and I just want to make sure we have a clean record. And if there's anything that's untoward, I need to point it out and or correct it. So the correction is, bless you, dog. Miss Watts Day, forgive me for the interruption. Please continue.
No problem. Okay, so one of the alleged claims was that he couldn't afford to stay there, he couldn't find employment, but in fact, he just voluntarily quit a job, correct?
That is correct.
Okay. And with regard to, a claim that he felt unsafe because his motorcycle was stolen, are you aware of whether or not that could be accurate?
After he moved to Indiana in December of 2023. I discovered driving by his previous apartment that the motorcycle had been abandoned there. And I have pictures of the motorcycle up to, I believe, April of 2024, that the motorcycle had just been left behind.
Were there any incidences in December of 2023 that caused you to be alarmed about the defendant's state of mind?
On December 9th of 2023, he called his friend Vince, who had previously taken the guns that Pine Rest said he needed to turn over during that time. He demanded all of those firearms back. He gave Vince about an hour notice that he was going to be coming by for them. Vince let him know that he was very uncomfortable with the situation. He was not sure that Chris was stable and should have the firearms. Chris showed up at their doorstep with a police officer in order to get his guns back.
And I'm gonna ask you to look at Exhibit 13. Is that the text messages from Chris asking for those firearms?
Yes, this is a text message from Chris to Vince saying that he needs those firearms because they believe that his girlfriend and girlfriend's kids are in danger from her ex.
Okay, I'm gonna move for the admission of Exhibit 13 as court's Exhibit 14.
Mr. Granley.
No objection.
Okay, Exhibit 13 will be entered into evidence as Exhibit number 14. That went a different way. I figured you were talking about hunting season, but
Right.
just timing. You know, it is Michigan. There are courts that actually recess for November 15th. So it's kind of like a holiday in certain northern parts of Michigan. Anyway, that'll be entered into evidence as Exhibit number 14.
Ms. Granley, following the incident that had occurred at the end of October with CJ and the defendant's removal of him from the state of Michigan, did you make a decision about proceeding with the divorce?
At that time,
This is good weed. It's pretty decent for the price, I'll tell you that. It is Kmetz. The bag is green is what I'm trying to explain. So the bag is green, but it's by Tweed, which their name pops out there. And it is a Kmetz hybrid with 26.4% THC. It's a hybrid, and it is, I bought it for $89 Canadian, and it was an ounce. So I've been smoking it for like a week. It's been good. Very nice.
I decided it would be in everyone's best interest to file for divorce in the traditional way, because we were clearly having a disagreement over custody and parenting time and what was best for the kids.
Did you experience, so is it accurate that we filed a complaint for divorce on or about November 14th, 2023?
That is correct.
To the best of your recollection, did we experience difficulties with getting the complaint served on the defendant?
Yes, we did.
And to your recollection, what were the issues?
He would not give us an address for where we could serve him. We asked if we could do it electronically to be done in a timely manner. He refused, said multiple times that I could not contact him on that any further, that he was going to get a lawyer and he would not be doing anything until we heard from his lawyer.
Do you recall when we were finally able to get him served?
I don't believe we got him served until the beginning of February in 2024.
And how did we finally have to serve the defendant?
We used a local police officer as a
Process server.
process server.
During that period of time or after the October 28th incident, what was your message to the defendant with regard to the parenting time issues?
At that point, I made clear to him that I was encouraging him to have as much parenting time as he wanted, but because of the events that have taken place, that I was not comfortable with that being unsupervised time.
Did you ever encourage the defendant to obtain, mental health help with regard to how parenting time would progress?
Yes, my only request to him moving forward with parenting time was that he was stable on his medication and not using marijuana, and then that he could prove that consistently. That was my only requirement for him to have unsupervised time.
Was that information provided to the defendant on multiple occasions by you?
Yes.
I'm going to ask you to take a quick look at what's marked as Exhibit 14. There's about 25, well, I shouldn't say about, there are 25 pages to Exhibit 14. I'm not going to ask you to go through every single page, but Is exhibit 14, text exchanges between you and the defendant?
Yes.
Can you briefly provide sort of a summary of the types of things that you guys are addressing through these text messages?
Mostly involving parenting time, as well as a couple financial issues. It is Chris asking for what he needed to do to see the boys, and me communicating that once again, my only requirement for him for having any unsupervised time was being stable on medication and refraining from using marijuana.
We're going to move for the admission of exhibit 14 as court exhibit 15.
Mr. Granley.
No objection.
Unfortunately, at this point, the court's going to have an objection. These look more like settlement negotiations, Ms. Watts-Day. I'm not sure the court should enter them as an exhibit. This looks like a negotiation between the parties from what I'm looking at. And I am uncertain, so please address that. I understand these are issues between the parties, but at the same time, forgive me, I quickly read through them because they were just presented to the court. Well, the court's had them, but I don't look at them until they're entered. But at the same time, I'm kind of grasping some of these pages, and they almost look like settlement negotiations, which disturbs me. The issues before the court are the issues before the court, but at the same time, nothing that entails settlement negotiations pursuant to court rule and statute should ever be entered. So please, why am I accepting this?
I would tell the court I would not view these as settlement discussions. My client makes it very clear throughout all of the text messages that she is not engaging in settlement discussions, that if he wants to have those discussions, he needs to go through his attorney, or if he was not represented at the time, that he could communicate directly with me as her attorney. What these are is, he's reaching out saying, I want to have time with children. And she's saying, that's fine, but my requirements have not changed. This
Right.
is why this is how I would be okay. There's also,
yeah, and those in accordance to Chicago terms, those kneecaps look really nice. It'd be a shame that something would happen to them while we're talking about it. I'm looking at this going, I'm sorry, I'm not entering that. I thought about entering it and going, there's no jury here. Hearsay doesn't apply. But I really have a strong problem with people trying to negotiate things and having that entered to the court. While there's no objection, the court has an objection, and I'm not entering that as an exhibit. So please proceed. I want to keep this on equal footing, and I'm not going to have them doing these. Yeah, I'm not negotiating, but I'm negotiating things. And 25 pages of that, no. So entry of that exhibit denied. Please proceed, Ms. Watts-Day.
Sure, Your Honor. I'm going to show you what's marked as Exhibit 15. Is this a document that you have created?
Yes.
And how did you come about this information?
Through reviewing text messages between Chris and I.
So what does this document summarize?
This summarized every time between November 2023. So November 11th, 2023, through present of every time that I offered him time or a visit to see the kids, as well as the ones that he accepted or ignored.
Okay. So you understand that defendant's position seems to be that you somehow withheld the children from him, correct?
Correct.
And is this representative of the offers that have been made, what occurred, whether he responded, and if they did occur, what kind of visitation occurred? That's correct. We look for the admission of Exhibit 15.
Mr. Granley.
I'm pulling it up real quick.
Yeah, that one's appropriate. So we're going to enter exhibit number 15 as exhibit number 16.
Yep.
Okay. Thank you. Please proceed.
I'm gonna show you what's marked as exhibit 16.
Yes.
What does this exhibit represent?
This is a summary of our FaceTime schedules. We attended mediation in August and both came to an agreement of twice a week FaceTime schedule that would be consistent for the boys. And this summarizes the FaceTimes that were scheduled and then were not made.
Okay, and have you,
My neurodivergent ass is just like freaking out. This is yucky. I don't even like listening to this. Imagine abiding by this. Imagine trying. Like, fuck, man.
consistently made the boys available for FaceTime based on your understanding of the agreement that was reached?
Yes.
And consistently has Mr. Granley made himself available, or has he attempted FaceTime?
No.
Have you communicated to Mr. Granley that you would be willing to look at other dates or times if he could be consistent with them?
Yes.
Has he ever provided an alternative suggestion that he could be consistent with?
We did 2 different schedules. We had the original schedule that we agreed to in August for Tuesdays and Thursdays. He later texted or communicated that he was not available on those evenings. I then offered him Monday evenings as a consistent schedule, which he again agreed to, and then never followed through.
We would move for the admission of exhibit 16.
Mr. Granley.
My only objection with that is that on several occasions, the plaintiff had blocked my phone. So as I was trying to call and set up different things to get things squared away, a lot of times.
I'm gonna object. That's not an
Hold
appropriate
on.
objection.
Let him make a record. And
Just several times the phone was blocked. That's all, sir.
yeah, and that's not an objection to the entry of this exhibit. This exhibit will be entered. I'm going to deny your objection and say you may cross-examine on it or enter other things that show that you were blocked. You have
Yes,
every
Your Honor.
right to
Thank
do
you.
So, okay.
Yes, sir.
Just trying to keep this fair and a level playing field. All right, Miss Watts-Day, please proceed. But that
Thank
will be
you.
entered. That is exhibit number 17, which was your exhibit 16. Thank you. I really wished we could have gotten back on the right numbers, but oh well. Even though I denied exhibit number 15, we're still moving on because exhibit number 15 is marked as denied.
I'm
One
gonna
off.
He innocently just thinks that's moving it along. Instead, it's rubbing salt on it. Oh, Judge, you're hilarious. Thank you for making me laugh.
Right. I'm going to ask you to, Ellie, to review exhibit 17. This is the supervision agreement that was signed by both you and the defendant, correct?
Correct.
That was also signed by the supervisor in this case?
That is correct.
Okay. Has Mr. Granley exercised parenting time under this supervision agreement?
Yes, he has.
And when did that first occur?
Just this past weekend.
Okay, and this agreement was just signed finally at the end of October, correct?
That is correct.
Are you comfortable moving forward with parenting time under this agreement?
Under this agreement, yes, I am.
And what is your understanding of the parenting time that has been agreed to based on everybody's schedule?
Like when it would occur?
Yes.
My understanding through this agreement is that the parenting time would occur the 4th weekend of every month.
Okay. To be clear, were you willing to allow parenting time, or would you have encouraged parenting time prior to what occurred just this past weekend, had this agreement been signed before?
Yes.
When was, to the best of your knowledge, when was this first presented to the defendant and his attorney?
Mediation that we had in August.
Okay. Was there, to the best of your knowledge, was there any issue on your side that would have prevented signing and entry of this agreement before it was actually signed?
None.
Did you ever refuse to sign it?
No.
Did you ever take the position that it needed to be modified or changed?
No.
Are you aware, or what is your understanding of why it wasn't signed until October 30th?
For Chris, we had an agreement at mediation for this parenting time schedule. Chris informed us after mediation that he no longer agreed to it. He had issues with it, and then it devolved from there.
We moved for the admission of Exhibit 17.
Any objection, Mr. Granley?
No objection.
That'll be entered as exhibit number 18 as exhibit number 17. Or proposed exhibit 17 as exhibit number 18. So, all right, please proceed, ma'am.
In moving forward, I want to talk a little bit about parenting time and the best interest factors. So I just want to clarify for the record, do you have any objection to you and Mr. Granley sharing joint legal custody?
No objection.
And you understand that that would mean that you two need to communicate as it relates to any important decisions that impact the boys' medical, education, religion, etc.
Yes.
Is that something that you've been doing?
Yes.
Do you have examples of where you've shared information with the defendant?
Our youngest son, Miles, has had some medical issues in the last year. Anytime that there has been an update with that condition, I have informed Chris what was going on.
Does Miles have an upcoming procedure?
Yes, he has a procedure next week.
And is that something that you made Mr. Granley aware of?
Yes.
Is he welcome to attend if he chooses to?
Yes.
Have you shared with Mr. Granley the expenses associated with that procedure yet?
I have not.
Okay. What have been your expenses associated with Miles' medical procedures?
I have paid his deductible for all medical procedures at this point and the therapy that he was involved in for it. I have paid the deductible out of pocket. And now starting for this procedure next week, I will pay the 20% co-insurance.
Okay. What has been the out-of-pocket expense to meet the deductible?
To meet the deductible is $2,000.
And is that something that you are requesting the court? Well, let me back up for a second. You are not receiving child support, correct?
Correct.
What is your understanding of the court's order from May of 2023 regarding child support?
The court did not put in an order outside of saying that it needed to be referred to front of the court because Mr. Granley was reporting that he was unemployed at the time. The judge's decision at that point was that they did not want to put in an order to put undue stress on him.
Now, she did indicate, however, that child support would be retroactive back to December of 2023, correct?
That's correct.
Is it your request that the court?
I apologize. What date?
December of 2023.
Okay, thank you. Okay. And that was Judge Bryant that
Correct.
did that? Thank you. Okay, thank you. Thank you for the qualification.
Sorry, just for clarification, there is an order in the court file, an order of reference that was dated May 24th of 2024. Referring this to the front of the court for child support with a retroactive date. It says starting 12/1/2023.
Thank you.
Is it your request that in addition to the child support, that the court order, depending on what the appropriate percentage is, that Mr. Granley contribute to the expenses that you've already incurred on behalf of the children from a medical standpoint, but also any future expenses.
Yes.
What is your understanding of your out-of-pocket expense for the procedure that's occurring on December 4th?
I have been informed that the 20% coinsurance for the procedure next week is $3,600.
And you will provide documentation with regard to that if necessary?
Yes.
Okay, but you don't have that at this point in time?
They
because it
just
hasn't
informed
occurred.
me on Monday what the cost would be.
With regard to the best interest factors, you do understand that the court has to look at the best interest factors as it relates to the boys in determining custody and parenting time, correct?
Yes.
The first factor is the love, affection, and emotional ties between the parents and the children. Do you have an opinion as to which one of you might have a stronger bond or emotional ties with the boys?
I would say at this point in time that I have a stronger emotional tie to the boys.
And why is that?
They have spent, Miles has spent all of his time with me, and CJ has spent the vast majority of his time with me.
And again, from your perspective, you believe you've offered opportunities for the defendant to spend time with the boys, correct?
That is correct.
For the vast majority of those opportunities offered, has he accepted that?
He has not.
Okay. Who provides for the boys' daily care?
I do.
And what exactly does that entail?
Getting them up in the morning, feeding them, changing them.
Moldy sippy cups coming from Dad's house. That's what our life entails. It's just she's laying it on too thick.
I'm getting them dressed, taking them to daycare, or some days they stay home with me as well. Any physical or emotional needs go through me.
And do the boys turn to you for their emotional needs?
Yes.
Okay. Do you have concerns with Chris's ability to contain his temper and not show anger or frustration around the boys?
If he is unstable on his medication, I have very strong concerns of that.
Do the children ask for their father? Do they seem to miss him? Are they, what are you observing as far as their relationship with their dad?
CJ is the only one talking at this point. I have not heard CJ ask for him or mention him. If we have a visit scheduled that I know is going to happen, then usually the night before, I start letting CJ know you're going to go see Dad tomorrow, and kind of prepare him in that way. So he is aware when Chris comes to pick him up or we have a supervised visit, that he knows that that's Dad during that time.
And Miles, obviously with the age, I don't know what's going on with Mr. Gramley's screen. Okay. Due to Miles's age, there's not a lot that you've been able to observe as far as any interaction or relationship with the defendant?
That's correct.
Okay. With regard to the capacity and disposition of the parties to give the children love, affection, and guidance, how do you provide the children with love, affection, and guidance?
Just time and attention.
And do you believe at this point in time that the defendant has been able to, or that he has provided love, affection, and guidance?
Not in an appropriate way at this point.
Okay. Do you think he could have, even given the separation, logistics, et cetera, could he have, if he had chosen to, been in a position to provide those things to the boys?
Yes, absolutely.
How do you think he would have been able to do that?
He informed us for a significant period of time of this year that he was unemployed and that he had a large amount of availability to be there for the kids. But despite that information that he provided, he was still not accepting the visits that I offered to see the kids.
What activities do you engage in with the children?
They go to daycare 4 days a week. Outside of that, we like to spend a lot of time outside, going to the park, playing with the toys together, and anything that involves connection between the boys.
Do you have concerns that the defendant is engaged in activities that impair his ability to exercise good judgment?
Primarily the marijuana usage.
Okay. And not being consistent with his medication?
Correct.
With regard to the capacity and disposition of the parties to provide the children with food, clothing, and medical care or other remedial care, who provides for the kids' basic needs?
I do.
Who provides medical insurance?
I do.
Who schedules and takes the children to doctor's appointments?
I do.
Has the defendant engaged in any of that since you two separated in June of 2023?
He has not.
Has he had the opportunity to, if he chose to?
When he was living in Michigan, I would let him know of any appointments and he was welcome to join.
Did he ever join?
No.
Has the defendant provided any financial support since the two of you separated for the benefit of the children?
There was a couple of small gifts early on, but no significant support.
Okay, and when you refer to gifts, what does that mean?
I would receive randomly a box of diapers, or at one point he gave me a bag that included vitamin gummies, a loaf of bread, and some Nutri-Grain bars.
But no financial support, no money?
No.
He has not used any of the income that he has made to provide you any support?
No, he has not.
What is your understanding of his current employment?
My understanding that currently he is working for his girlfriend.
Okay. Do you believe he's maximizing his earning potential based on past history?
No.
Do you have concerns with job stability based on his past history?
Yes, I do.
Oh, hold it. I'm sorry, I was muted. How old is the oldest?
He is 3.
Okay, sorry, I interjected when you mentioned the Kind bars, I think it was.
Nutri-Grain bars.
Nutri-Grain. Are those made for 3-year-olds?
He's able to have.
Nutri-Grain bars are fine for 3-year-olds, Judge. They're fucking fine. 3-year-olds can eat anything. There's no concern at that point. As long as it's properly portioned and under supervision, anything's a choking hazard when it's not. But yeah, a Nutri-Grain bar is completely within the realm to give a 3-year-old. Absolutely. There's no fucking, like, absolutely no problem with that whatsoever. Like, whoever thought I would defend the Nutri-Grain bar, which I hated growing up. I fucking hated Nutri-Grain bars. I don't know why. Just wanted the chewy granola bars and never got them. Always had a Nutri-Grain bar. And, you know, I'm sure I could still have Nutri-Grain bars. I've never bought one as an adult for myself.
Have them, they're not a significant part of his diet.
Understood. I'm just sorry. I was trying to put age appropriateness to the gifts that were given. And forgive me, I somehow, thanks to my big belly, I knocked the fob on this thing and muted myself. That's normally my clerk's job to keep me from talking. But anyway, I was just trying to, you know, as we're talking, as I'm listening to testimony, I am trying to think about what I'm hearing. And I was trying to make sure that, because I thought they were very, very young. And I'm like, a Nutri-Grain bar sounded a little bit odd for a 3-year-old, but please continue.
Thank you. With regard to the length of time, the children have lived in a stable, satisfactory environment and the desirability of maintaining continuity, which is factor D. What is the kids' current environment?
They live with me full-time in a stable, calm environment.
Okay, and can you just describe your residence for the court so it can get an idea of their living environment?
Yes, we currently live in a townhome. They both have their own rooms. It is just me and the boys.
Okay. There was a short period of time that you did live with your parents, correct?
Yes, when I initially moved out of our marital home, I moved in with my parents because I was pregnant along the way, and I wanted to get past my maternity leave before getting into my own home.
And so when did you get into your own home?
October of 2023.
Okay. And do you see a move in your future at this point in time?
I do not.
Okay. What is the defendant's living situation since separation, to the best of your knowledge?
He moved out of our marital home, which was the condo that we were renting. He moved out of there in the end of August of 23. He moved into an apartment in Kentwood. My understanding is that he lived there for about 4 months. And then in December, he broke that lease and moved to Indiana to live with his girlfriend.
And at some point in time, during that period of time, he also said he was gonna live out of his car.
And right after I moved to my parents, when the separation first happened, his first indication was that he was gonna live out of his car.
And the children have resided with you 100% of the time since the separation, correct?
Chris had CJ for 2 days out of the week between June and October of 2023. Outside of that, they have been with me.
Okay. And you've already testified, there's nobody else living in your home besides you and the children. Do you know who is residing in defendant's residence? I know you mentioned he moved in with his girlfriend, but do you know anybody? I mean, do you have any specific knowledge about who all lives there?
I believe she has 2 girls. I do not have knowledge outside of that.
Okay. The factor E is the permanence as a family unit of the existing or proposed custodial home. It sounds like your testimony is you intend to stay where you are, and are you seeing anyone?
I am not.
Okay, do you have, you can't obviously predict the future, but do you have any intentions of getting into another relationship in the near future?
Not a serious relationship anytime soon.
Okay. Do you have concerns about the permanent?
Hold on, she didn't say not a relationship. She said not a serious relationship. She'd be fucking everybody. Is that what we're hearing? I'm fine with it. Oh. I've broken so many things today. Part of me feels like going and fucking some shit up, you know? This lady.
Of the family unit as far as the defendant is concerned?
I do.
And why do you have those concerns?
He indicated that he was not in a relationship with his girlfriend for a very long time, that he would not be, and then that changed within a matter of 3 weeks that he ended up moving in with her. And there was just evidence of manic behavior or unrational thinking.
Okay. Were you aware, or had you been made aware at some point in time between December when he moved in there and now that he had supposedly had a falling out with her and was potentially leaving Indiana and moving back to Michigan?
Yes, 2 months after he moved in with her, so it would have been in February of 24.
MB, I love what it says. 1999 from MB, my love, MB. And it says pair character sliding on the floor on his knees saying, "Go!" I love you so much. I love that descriptor. I love everything. I mean, Streamlabs and I are going to have a talk later because apparently this one's coming late. That's what she said. But anyways, thank you, MB. I wish I had the whole fucking thing. I swear to God, I'll work on getting it. But, yeah. It ends quite abruptly. We'll see.
I learned that he had had some kind of a falling out with her, and he was thinking that he was going to come back. He wanted to try to repair things so that he could see the boys.
And what happened after that, to the best of your knowledge?
To the best of my knowledge, they patched things up and he still lives with her.
Okay. Factor F is the moral fitness of the parties involved. Do you use illegal substances?
I do not.
Do you have any sort of criminal record?
No.
Is there anything that the court should be aware of with regard to your moral fitness?
No.
Okay. Do you have concerns with regard to the defendant's moral fitness?
Yes.
Can you describe to the court what your concerns are?
The excessive marijuana usage, and in regards to his medication, as well as providing that marijuana to minors.
Okay. Has the defendant, I mean, I think we've already addressed this, but I want to confirm, has the defendant either verbally or physically abused you in front of the children?
Verbally, yes.
Okay. To the best of your knowledge, does the defendant have a criminal history?
Not that I'm aware of.
Okay. Have you witnessed any verbal, emotional abuse by the defendant against the children?
In his limited time, I have not seen that, no.
Okay. Factor G, the mental and physical health of the parties. Do you have, well, I guess first, as it relates to your physical and mental health, are you healthy? I don't know what happened to Mr. Granley.
Oh, great. Sorry, I missed that he.
He just messaged me. His computer dropped audio. He's gonna
Okay,
log
get
off
him-
and back in again.
we'll get him right back. Sometimes I pay too much attention to one thing instead of the other.
I hear you, Judge, but they did not indeed come.
Not
in.
yet, Mr. Granley. That's okay. I'm just realizing I didn't marinate the turkey at lunch like I was supposed to. 5 hours off. It should be overnight. It'll be okay, right?
It'll be fine.
I'm doing it a different way this year. I normally get one of those adult.
Adult what? Adult turkeys? Adult what? It was the weirdest fucking cliffhanger. Like what? That's how that hearing ends, and they never came back. Adult. I have so many questions. Oh, you guys, what an evening, what a night. We had such a fun time together. Oh, the fireplace. It's so warm. I love being warm. I set up this to redirect to the chase. I don't know if it's still live or not, but I figure it may as well try. Anyways, that's what I had for you this evening. I'm sorry I don't have more, but that is indeed how it ended. I hope that I will be able to catch the rest of it. I'm assuming the time of day was late, and I assume that they would have had to reschedule anyways, so that's what I'm gonna guess would happen. And we will be looking out for the next case. I hope you all had a wonderful Thanksgiving. I will be back at you this weekend. Remember, members only. And it's gonna be such a fun time. Such a fun time. Oh, did you hear that? They're coming for me. I have to go quick. Remember that I love you and I'm proud of you. And I'll see you in the next video. Okay? Bye.
Ways down red.